Part 1 of the history of the Kentucky Constitution. Kentuckians have written and adopted 4 constitutions, one each longer than the former, with the current charter of such length as to almost to represent a code of laws. Without much experience from which to generate problems and the needed solutions, the framers of the first constitution drew heavily from other state constitutions, while the drafters of the remaining charters based most of the reforms on the perceived deficiencies of existing constitutions. The road to statehood. Kentucky was unorganized wilderness until 1776, when it became westernmost county of Virginia. As Virginia divided Kentucky into additional counties, it became known as the District of Kentucky. 1 year before, Richard Henderson, a land speculator, attempted to separate Kentucky from Virginia by establishing the independent colony of Transylvania, but his efforts failed. Thereafter, efforts at separation mostly involved movements for statehood, either with or without permission of Virginia, although a few settlers entertained notions of making Kentucky an independent nation allied with either Spain or Great Britain. The quest for valid land titles formed a principal issue of these efforts, an endeavor rendered more complicated by competing sources of real estate grants. Virginia granted land titles as a way of paying its Revolutionary War soldiers, while other individuals claimed titles from Indian tribes or as squatters. The latter two groups often favored separation without Virginia's approval as a method of perfecting their land titles against grantees from Virginia. Confusion about land titles would persist throughout Kentucky history. Virginia's Constitution of 1776 provided for the possibility of Kentucky becoming a separate state, and serious agitation for that result began in 1784 as the population of the district began to increase significantly. In late 1784, Kentuckians held the first of 9 conventions on the question of statehood, where delegates delineated grievances against Virginia, including the difficulty of judicial appeals, inadequate legislative representation, delays in receiving new statutes, an unfavorable balance of trade favoring the eastern part of the state, an unfair system of taxation, and the appointment of non-residential government officials for the district. Okay. As the 7th Convention convened in November 1788, General James Wilkinson, the leader of the so-called Spanish conspiracy, made a concerted effort to create a separate state of Kentucky, which would either join the Union or become a new part of New Spain. The United States government cannot persuade Spain to open the Mississippi River and the port of New Orleans to Kentucky traders, but membership in the Spanish Empire would achieve such a result. Despite the deep frustration felt by Kentuckians because of their inability to ship their exports to market down the Mississippi and through the port of New Orleans, the convention rejected Wilkinson's proposal and again voted to petition Virginia for statehood. So they almost became a Spanish colony. So Kentucky almost, where everybody's like, oh, come here and speak English and shit. Well, Kentucky almost voted to become a Spanish colony. We were the English colony, right? We have to be like kissing the crown's ass, somebody's ass. It's got to be the French crown, the English crown, or the Spanish crown. And so we keep on trying to kiss the fucking Spanish or the English people, right? Lord Dunmore, please let us be a state, Lord Dunmore. The political leaders of Virginia understand that Kentucky lay too far away for proper governance. Were quite prepared to grant the district separate statehood provided that certain conditions were met. After several enabling acts had been rejected either by Kentuckians, the U.S. Congress, or both, Virginia finally enacted a statute on December 18, 1789 that met the approval of both and served as a prelude to statehood. The enabling act became known as the Virginia Compact and set forth the conditions of Kentucky statehood, which include recognition of the validity of titles to land in Kentucky granted by Virginia and the assumption by Kentucky of Virginia's share of the federal debt. In 1790, the 9th and final Kentucky Statehood Convention called for a constitutional convention to convene in April 1792 to draft a constitution for the new state of Kentucky. On February 4th, 1791, Congress enacted a statute admitting Kentucky to the Union, with admission to occur on June 1st, 1792. June 1st, 1792, happy birthday, Kentucky, woo! Popularly elected delegates to Kentucky's 1792 Constitutional Convention lacked political experience and deferred to George Nicholas, a former Virginia lawyer, for many of the ideas that formed the state's first constitution. So, 1972, George Nicholas, one of the only two lawyer delegates, in turn borrowed much of his thinking from Pennsylvania's Constitution of 1790. A full 75 of the 107 sections of the Constitution were taken verbatim and substantially from the Pennsylvania Charter, including 27 of the 28 sections of the Bill of Rights. The Constitution, with Nicholas's support, provided that all free male citizens of the age of 21 years could vote whether or not they own property if they meet the residence requirements. So that means if you're under 21 years old and you're a white male, you could not vote. And if you had property or did not have property, so that's a good thing about the property, no property requirements. But if you're a black, if you're a woman, you couldn't vote. If you're a white male under 21, you couldn't vote. But there was no property requirements. So that was progressive because of that one part, right? There was disagreement about whether the provision actually extended the right of suffrage to Kentucky's small population of free black males. Most students of the question saying it did, but some saying that free blacks were not citizens. The charter also created a popularly elected lower house of the legislature with representatives to serve for one-year terms. However, electors chosen by the voters would elect both the state senate and the governor both for four-year terms. The governor, because he could succeed himself and appoint most state and local officials, would be one of the most powerful state chief executives in the nation. Further, to be overridden, his vetoes required a two-thirds majority in both legislative houses. So that means both legislative houses, two-thirds, had to override a veto, one of the most powerful ones. The Constitution created only one court, a Supreme Court, known as the Court of Appeals, and left to the legislature to establish such inferior courts as it deemed necessary. So there's only the Court of Appeals. That was only one court in Kentucky, although primarily an appellate court. The Court of Appeals was given the original jurisdiction over land cases in the hope it could equitably settle the many competing claims to the Commonwealth's real estate. Judges would be appointed by the governor with the consent of the Senate for life on the condition of good behavior, and each county voters would elect sheriffs and coroners for three-year terms, a former being prohibited from succeeding themselves. So they could only serve one term, and that was it. The first Constitutional Convention represented the best opportunity before the Civil War for Kentucky's anti-slavery advocates to abolish the peculiar institution. 7 emancipationist Protestant ministers having been elected delegates to the convocation. However, these would-be reformers only succeeded in increasing the resolve of the pro-slavery majority to protect what they perceived as their property rights. So this is a lot of times I see Protestants being like the main bloody aggressors, but here you got a few Protestants standing up against slavery in the 1792 Constitution. So the Article 9 of the first Constitution prohibited the legislature from providing for the emancipation of slaves without the consent of and full compensation to the owner. Immigrants could bring slaves into the Commonwealth, but the legislature could prohibit slaves being brought into the state as merchandise or as imports from foreign countries. In sum, Article 9 represented a powerful endorsement of slavery, which would not be diminished until rendered invalid by the 13th Amendment of the Federal Constitution. The Constitution also contained a Bill of Rights, which included many of the same freedoms recently appended to the Federal Constitution, including freedom of and from religion, right to trial, jury, freedom from unreasonable search and seizure, and prohibition of double jeopardy, ex post facto laws, and laws impairing the obligation of contracts. All these rights would be found in Kentucky's subsequent constitutions. George Nicholas and the other delegates to the 1792 convention did not submit their new constitution to the voters for ratification, nor did they regard their document as anything more than an experiment that would have to be revised in the near future. To that end, they provided that if a majority of those voting for representatives in 1797 and 1798 favored a constitutional convention, such should be called by the legislature at its next session. Only a convention could revise or replace the first Constitution, which did not provide for adding individual amendments. So you couldn't add any individual amendments, right? And so they were having a problem with even being able to call another constitution by the mechanisms that the first Constitution had put in place. This is something that's the current Constitution. It does not allow for something simple, like for some easy convention to be called. So I think a convention just has to be called and then just let the ball roll from there. Rand Paul mentioned having a constitutional convention, so it has been on the representatives' minds. Each of the three major branches of government came under attack during the brief period of the first Constitution. In 1794, the Court of Appeals, in a 2-to-1 decision in the case of Kenton v. McConnell, ruled that Virginia Land Commission Court had exceeded its authority when determining the rights of numerous land disputes in Kentucky in 1779 to 1780. Because this decision undermined the land titles of thousands of Kentuckians, it created a major public protest, prompting the legislature to attempt to remove by address to the governor the two majority justices of the Court of Appeals, the Constitution empowered the governor to remove any judge for any reasonable cause, which shall not be sufficient ground of impeachment on the address of 2/3 of each branch of the legislature. So they were allowed, they were for life, but in unlikely cases they could remove them, and so they were trying to remove the judges because of the land disputes. Kentucky will have land disputes from then till today. The removal resolution failed to receive the necessary 2/3 majority in the Senate, and the House contented itself with the resolution of censure that branded the judges unfit for office. The offended jurist refused a House summons to appear before that body on the grounds it had no right to interfere with the judicial process. In the following year, one of the majority judges quieted public outrage by reversing his opinion on the case. So we're seeing lots of problems with the first Constitution. To lessen the possibility that the Court of Appeals would again threaten the sanctity of land titles, the legislature in 1795 removed the tribunal's original jurisdiction over such matters. In the same year, the General Assembly abolished the Court of Oyer and Timoner, which had been formed in 1792 as the principal tribunal of original criminal jurisdiction, and whose performance had been marred by the mediocrity of its underpaid judges. So the court systems that it put in place isn't very effective. The legislature transferred the jurisdiction of the Court of Oyer and Timoner, as well as original jurisdiction. It's weird names, Oyer and Timoner. So over to land cases, to 6 newly created district courts. So now you got 6 district courts that they create, which together with the already established quarterly session courts constituted the principal trial courts. The executive branch became involved in controversy in 1796 when the Electoral College failed to give any of the 4 candidates for governor a majority of its votes. Instead of declaring Benjamin Logan the candidate with the plurality of votes the winner, the college conducted a second ballot between the 2 highest vote getters. On that ballot, James Gerard, who had finished second on the first ballot, received the majority of votes, and the college declared him the next governor. Logan and his supporters protested, arguing that because the Constitution made no provision for a second ballot except in case of a tie, by implication plurality was sufficient to elect, that's right, they're right on that argument. So the fact that they even went along with this horse shit is bullshit. But Benjamin Logan's a dickhead. James Gerard, I think, might have been a better guy anyways. So the Attorney General, John Breckinridge, unofficially endorsed this interpretation, but the Senate, which was empowered by statute to settle disputed gubernatorial elections, declined to intervene and declared its authority unconstitutional. Logan ceased his protest rather than risk undermining the stability of the government. Within the legislative branch, the Senate engendered much controversy by approving a controversial land sale, never approved by the House, delaying passage of a popular land claimant statute, and approving the legislative pay raise. Certain of the senators increased this negative public opinion by resigning to accept lucrative political appointments. Within a few years of the first Constitution inception, many Kentuckians regard the Senate as a rich man's club, which was undemocratically elected and in need of basic reform. The second Constitution. Complaints about the decisions of the Court of Appeals, the method of electing the governor in the Senate, the conduct of latter datless contributed to the overwhelming popular endorsement of a convention call in the legislative decreed referenda of 1797 and 1798. So again, it took 2 years before the actual fucking Constitution to be rewritten. 1797, 1798, and then the second Constitution will be the one of 1799. And this is only 7 years afterwards, right? So, it's not even good, and they're already throwing this shit out. The convention met on July 22nd, 1799, and finished its business in 27 days. Not surprisingly, it abolished the Electoral College method of choosing the governor and senators, opting instead for direct election of these officers by the voters. The governor, the incumbent accepted, could not succeed himself, it's a weird fucking law. That law will stay for Kentucky forever. So you got all these governors just being governor for 4 years, and then they sit down, and that's it. What the fuck can you do in 4 years? But he retained most of the patronage powers and a diluted veto power, which could be overridden by a simple majority, not 2/3 as before. The delegates also created for the first time the office of lieutenant governor, who would preside over the Senate. So it was a strong governor constitution in the beginning. Now it's a weak governor constitution, and they even added a lieutenant governor, so they completely diluted all the power that the governor has. And then even emasculates the fucking lieutenant governor to just be another fucking asshole just watching over the Senate. He can't propose anything. He just watches and observes, make sure the shit's happening. So that's a little bit of background on Kentucky's first Constitution. There's overall 4 constitutions, unless you count the Confederate Constitution. There's 26 sections, 26 freedoms, and I'm gonna read the 26 freedoms coming up.